Welcome to Grant or Deny, a government contracts claim talk show that breaks down legal arguments and predicts, based on the record, whether the board will grant or deny the appeal. I am your host, Kelsi Pilcher, contracts trial attorney for the United States Air Force, and I am here today with John Nakoneczny from Crowell and Mooring's DC Government Contracts Group. Thank you so much for joining me today.
Thanks for having me, Kelsey.
Alrighty, so today we are going to break down 3 contract claims. John, are you ready to get started?
Yeah, let's do it.
First, we have Five Stones Intelligence Incorporated versus the DOJ before the Civilian Board of Contract Appeals. Here are the facts. The parties have collectively filed a joint motion to dismiss. The dismissal is based on a lack of jurisdiction, and the parties stipulated that the contractor never filed a claim and the contracting officer never issued a final decision. Will the board grant or deny the parties' motion?
I'm going to go with grant on this one. So this seemed like a straightforward issue. It's really Contract Disputes Act Jurisdiction 101. So in order for the board to have jurisdiction over an appeal, there needs to be a valid contracting officer's final decision. And if you're dealing with a contractor claim, then there also needs to be a proper claim asserted against the government. Here, both of the parties stipulated that both were absent, and so it seems like it was a straightforward decision for the board.
Nice, and you are correct. So although Board Rule 12 permits parties to jointly request a dismissal without prejudice, the parties don't have authority to independently determine whether the board has jurisdiction. So here the board actually directed the parties to explain their reasoning for finding that there was no jurisdiction, and the board later agreed based on the stipulation and the following correspondence that was provided. So you're absolutely correct. Thank you so much for that one. Moving on to our next appeal, we have Balfour Beatty Construction LLC versus the General Services Administration before the U.S. Court of Appeals for the Federal Circuit. In this appeal, we will discuss when an implied warranty is enforced. Here are the facts. The construction contract underlying the dispute required the contractor to complete existing designs that were only 30% complete. The contractor first needed to validate the designs before completing and constructing the project. On appeal, the contractor addressed the increased cost incurred as a result of the alleged design defects related to the thickness of the slab foundation. The slab foundation contract drawings required the contractor to match existing building foundations, which were about 18 inches. However, the government's consultant their calculations were shown to be about 24 inches thick. Will the board grant or deny the contractor's claim for additional costs?
I'm going to go with grant again.
Okay.
But to be fair, I think that this one was a little bit easier to predict because of the way that the court had drafted its decision. But what I thought was interesting was how the Court of Appeals focused on the language that the design specifications or the design drawings provided that the contractor needed to match the existing building foundations. So as you're aware, when it comes to specifications, when there's a performance specification, it's sort of like the government saying, this is what I want it to do. And when you're dealing with a design specification, that's more akin to the government saying, this is how I want you to do it. And with that design specification, there's an implied warranty that if you follow the government's directions, then the end result will be satisfactory to the government. Now, the civilian board, it didn't find that there was an implied warranty because there was an apparent discrepancy before award where the design drawing said you need to match these foundations, and those foundations showed that it was supposed to be 18 inches thick. But other calculations provided by a government consultant showed that the foundations needed to be 24 inches thick. And this sort of prompted the board to say, well, this discrepancy should have alerted you to this, and so there's no implied warranty. Whereas the Court of Appeals took a different tack. They honed in on this language within the design drawings and said it's directing the contractor to match the existing building foundations. That's a design specification, and the warranty applies. So I think that was an interesting way of how the board versus the court viewed the documents.
Absolutely. And you are correct. That's exactly how the board ruled with a design specification regarding the slab foundation, the implied warranty attached. So there you have it, another correct prediction. Alrighty, so our final claim in today's show is actually a little bit hairy. The appeal of Sheffield Barbers LLC before the ASPCA distinguishes the contract principle of waiver in the context of haircuts. Here are the key facts. This case involves a concessionaire contract for a barbershop on a base. The contract provided that the shop was permitted to charge two fixed rates for different categories of haircuts. Regular haircuts were distinguished from style haircuts, and those style haircuts cost a bit more. However, the agency's policy was that the military regulation haircuts were to be charged at the lower regular haircut rate. For more than 15 months into the performance period of the contract, the barbers charged style cut prices for the fade hairstyle, and that required a little bit more tapering and technique. This approach to pricing fades was consistent with the previous contractor, and it was also consistent with what the government shared the revenue from the previous contractor as well. Later on, throughout the performance, the agency received complaints from customers who were being charged more for the fade haircut, even though that was the military regulation style. The agency directed the barbers to charge regular prices for fade styles and eventually told the contractor to stop charging the higher price for style cuts altogether. The contractor later filed a claim for over $300,000, and the CO denied that claim. While on appeal, before the board, the government moved for summary judgment against all three counts of the contractor's complaint. And those counts included that the agency breached the contract by requiring a price reduction in fade haircuts that resulted in a lost revenue. The agency constructively changed the contract by requiring the barbershop to recategorize the fade haircuts as regular haircuts. And lastly, the agency provided unreasonable estimates in the solicitation in the contract. Will the board grant or deny the government's motion for summary judgment?
So I'm going to go with deny on this round.
Okay.
But before I share my opinion about the case, I just want to say I was blown away by the fact that the haircuts only cost $8.95. I would love to find a place today that can get a haircut for under $10.
I also would love that.
Sure. But regarding the facts of the case, so I think it's important to first keep in mind what the standard for summary judgment is. And so for a non-movement to survive summary judgment, they just need to show that there's some sort of material dispute of fact, and the board is going to take every reasonable inference in the favor of the non-movement. And so here, the way that the facts were laid out, it seemed that the board was going to find that there were triable issues of fact because they honed in on the fact that the government had not enforced this pricing requirement for, I believe it was 15 months with this contractor at issue, but also they hadn't enforced it for the previous contractor. So taken together, that showed that there was a triable issue of fact as to whether or not the government had waived the requirement or if they subsequently changed it by demanding that the pricing be consistent with the original requirements. I also recall that the government at one point directed the contractor to charge the lower rate for all haircuts that they were doing. As for the negligent estimate theory, I thought that was interesting that it survived, but it makes sense because the contractor was well aware that the pricing, that data that they had received was inconsistent with the requirements. They had also gone firsthand to the barber shop while the previous contractor was working and seeing how the pricing had been done. And also, they even communicated to the contracting officer that, hey, this is an issue. So apparently, the board found that it was difficult for them to be misled by this pricing data.
Absolutely. So the agency, according to the board, waived its interpretation of the contract by non-enforcement of those provisions, precluding it from changing the pricing without properly compensating the barbershop. And that wraps up today's episode of Grant or Deny. If you enjoyed our discussion or learned something new, we definitely would invite you to visit our Board of Contract Appeals Bar Association website, and we'll link that information in the show notes below. If you're not already a member, we also invite you to join. Thank you so much, John, for joining me today in this great discussion, and we'll see you next time on another episode of Grant or Deny.